ground rules, and some information that may be helpful to you as we proceed with today's town hall. This town hall meeting is not being recorded because we wanted everyone to feel comfortable asking their questions anonymously without concern. If you have a question, you can submit the questions through the Q&A box. Please be aware that the questions submitted through the Q&A box will not be anonymous unless you check the box to ask the question anonymously. Let me repeat that one more time. Please be aware that the questions submitted through the Q&A box will not be anonymous unless you check the box to ask the question anonymously. For the questions we received in advance through the survey, we have made every effort to incorporate those questions in today's town hall. Please know that we may not be able to answer every question during today's town hall due to time constraints, and we also want to be respectful of everyone's time this afternoon. However, your questions are important to us. At the end of today's town hall, we will provide a survey link to receive your feedback, as well as give an opportunity to submit additional questions or resubmit questions that we did not have time to address this afternoon. In the survey link, we can respond directly to you if you are comfortable providing your contact information. We will also review the questions to help inform us if the questions can be addressed in a future town hall series. Please be aware that the judges on this panel are bound by ethical canons which prohibit discussion about specific cases pending or filed before the court. And judges are not allowed to take public positions on political issues. This may also be the case for some of our panelists as well. However, we will do our best to answer your questions, but wanted to be transparent about our ethical limitations and responsibilities. So, having said all of that, I would like to now turn the town hall over to our presiding of juvenile court, Judge Ana Espana.
Thank you very much, Judge Martin. And so very happy to have this opportunity to present to all of you, our community, about the work of our juvenile court. As judges, we preside over children who have been impacted by very traumatic events, including severe neglect, physical and emotional abuse, or molest. There is a strong public policy in keeping juvenile court proceedings confidential in order to protect our most vulnerable population from unnecessary emotional harm that could result from public exposure. Also, we work with parents of these children, most of whom have been impacted by trauma themselves. Most of our families struggle with either substance abuse, mental illness, domestic violence, or a combination of all these factors. These are private and difficult situations that parents should be able to talk about within the confines of the juvenile courtroom. At the same time, we know there are many questions about what happens when a family becomes involved in the juvenile dependency court, and we'd like to share our world with you as best we can by hosting this virtual town hall. You will meet participants in the process from judges, social workers, attorneys, and CASA volunteers. They will talk about how a case comes to the juvenile court, what decisions have to be made throughout the time the family is involved, and they'll describe their own roles and responsibilities in that process. I was asked to take a few moments to provide you with a very brief overview of the dependency court system. Decades ago, the California Supreme Court said that the objective of the dependency scheme is to protect abused or neglected children and to provide permanent, stable homes if those children cannot be returned home within a prescribed period of time. That is true today. There are three primary goals for each child made dependent of the juvenile court. First, the safety and protection of the child. Second, preservation of the family. The goal is reunification in most cases as early as possible, whenever possible, if it can be done safely. Typically, the reunification period is between 12 and 18 months. It could end as early as 6 months in certain circumstances. It could extend as far as 24 months, again, depending on the circumstances. Once it is determined that the allegations of abuse are true, the family, their supports, and the social worker come together to develop a case plan that describes the services the social worker must offer and the services the parents need to participate in order to address the reasons for court intervention. The court typically orders the case plan with perhaps some modification after hearing from the attorneys. If a child cannot return home within a prescribed timeline because it's not safe, then we turn to a permanent plan of perhaps adoption, guardianship, placement with a fit and willing relative, or another permanent plan living arrangement. You'll hear more about this throughout this next hour and a half. The juvenile court judge oversees the entire process from the family's entry into the dependency system to termination of court jurisdiction. We recognize that our decisions impact lives, and to make the best decisions possible, we rely on the information we receive from parents and children, family members, service providers, and those you will hear from this afternoon. So with that, I would like to introduce our panelists. I'm very thankful for them being here with us today. They are Alfredo Guardado, Assistant Director of Child Welfare Services, Lisa Maldonado, Chief Deputy County Counsel from the San Diego County Health and Human Services, Chief Deputy County Counsel, Carolyn Griesemer, Executive Director of Children's Legal Services of San Diego, Adam Reed, Managing Director of Dependency Legal Services, Judge Marisa Bejarano, Dependency Judge with the San Diego Superior Court, and Stephen Moore, Chief Program Officer for Voices for Children. Again, thank you all so much for being present today. As a starting point, we've asked each of our panelists to prepare a short 5-minute presentation to give the background of their organizations so that we have a good foundation as we jump into the questions and, most importantly, the answers. We will begin with, let's start with Child Welfare Services and County Counsel. Alfredo?
Thank you, Judge Espana. Good afternoon, everyone. I'm very excited to be here today. My name is Alfredo Guardado. I'm one of the Assistant Directors for Child Welfare Services. I've been employed with Child Welfare Services for over 24 years. I've served in multiple roles and programs during my time in Child Welfare Services. Child Welfare Services, our main task is to investigate allegations of abuse or neglect in entering with families when they don't meet the minimum standards for community standards for health and safety as required by law. Our agency, our department has about 1,600 staff members. We investigate allegations of physical abuse, emotional abuse, sexual abuse, neglect, exploitation, and caretaker incapacity. Child Welfare Services is committed to excellence in the delivery of culturally competent, family-centered, and child-focused protective services. Investigations are conducted in a thorough and professional manner. Every family interventions are completed with the least intrusive manner necessary for the protection of the child. In addition to some of those services, one of the specific services that we have in Child Welfare Services is we operate a couple of specific units, and I just wanted to take a few minutes to kind of talk about those units. And one of those units is the Indian Specialty Unit. San Diego County has the largest concentration of Native American tribes, with 18 federally recognized tribes in San Diego County alone. So in Child Welfare Services for the County of San Diego, we have a unit that focuses in on working cooperatively in partnership with our local tribes with any investigations within our tribal territories. We also have other types of units, for example, like our medically fragile unit, and we also operate what's called an emergency 24-hour facility for children that do need to be removed from the care of the parents while we're looking for a more permanent type of situation for them to be placed in, and that's called Polisky Children's Center. I think most of the most of the people in San Diego have heard of the Lusky Children's Center. So that's just a brief overview of child welfare services. So with that, I'll hand it over to my partner, Lisa Maldonado.
Good afternoon, everybody. I'm so happy to be here. My name is Lisa Maldonado, and I am the Chief Deputy of our Juvenile Dependency Division here at the Oxford County Council. And I similarly have been working in the juvenile dependency field for 24 years now. I started out representing parents and some children before moving to the Office of County Council. And just a little bit about what the Juvenile Division is and what it does. The Office of County Council, and specifically the Juvenile Dependency Division, represent child welfare services in three crucial ways, really. We have the county councils embedded in the agency's regional offices to meet with them and advise with them on investigations and legal issues. And then we have a large team of lawyers appearing throughout all of the juvenile dependency proceedings, representing the Child Welfare Services Agency throughout those proceedings. And then finally, when those cases are appealed, we have a team of lawyers who handles those juvenile dependency cases on appeal. So that's sort of a thumbnail sketch of who we are and what we do. And I think we'll touch on a lot of those topics later on as we continue with the presentation. So I'll turn that over to Carolyn.
All right, Carolyn.
Thank you. Hi, my name is Carolyn Griesmer, and I'm the Executive Director of Children's Legal Services. In California, we provide court-appointed counsel to children ages 1 day to 21 years in the state. And so our clients range anywhere from infancy to toddlers to youth that are emancipating out of the system. When a petition is filed is when the children have the right to counsel. So we enter into the case at that first day that the petition is in court to meet our clients. We have more than 20 lawyers on staff and 10 investigators. And our interdisciplinary team meets with the youth, learns what their wishes are, their positions are in the cases. And we really strive to keep these children with their families whenever possible, primarily with their parent when that's safe to do so. And if not, with relative caregivers or foster families that can provide them safety and stability throughout the services and the length of time that they're in our court system. Children deserve to feel safe and heard, and we really want to honor their individuality, listen to who they are, what their cultural traits are, what their cultural beliefs are, and make sure that they're plugged into their own neighborhoods and families whenever possible. We advocate in court for them to have access to education, healthcare, mental health care, and we currently have approximately 2,300 clients. 850 of those clients came in just last year through petitions filed in the court system in 2022. So that's just a brief overview of children's legal services, with our clients being the kiddos system.
All right, thank you, Carolyn. Let's go down to Adam.
Thanks, Judge. My name is Adam Reed, and I'm the Managing Director of Dependency Legal Services San Diego. We represent parents who come into the juvenile dependency system. And like Children's Legal Services, we only become involved once there's a court case. California law provides that every parent whose child is brought in front of the juvenile court is entitled to competent counsel at every stage of the proceeding. And that's not necessarily the case in other states, but in California, you're entitled to a counsel at every stage of the proceedings. A parent simply needs to ask for a lawyer. This can be done in person. Nowadays, it can be done virtually. Sometimes we accept new clients because a client has told a social worker that they want an attorney, and that social worker has let our office know, and we will reach out to that individual and provide assistance if that's possible. So it's easy to get a lawyer with TLSSD if you have a case in court, and that's our mission, is to provide representation to parents in the dependency court. We've been doing it here in San Diego since late 2016. We represent about 2,000 parents currently. And even though our organization has existed here only since 2016, much of our staff was here well before 2016, providing legal representation to parents in San Diego County. So we have a lot of experienced local practitioners. My personal background is that I've been working in the juvenile dependency field since 1997. So for about 26 years now. We currently have 15 staff lawyers. We'd like to have 17 staff lawyers. And that's usually where we're about, between 15 and 17. And we have a few social workers that support our clients and also support our litigation teams. One thing I said earlier was in San Diego and in all of California, you have a right to competent dependency counsel. In San Diego, we do something a little different in that in order to practice, in order to be court appointed, you have to actually file a certification in the presiding judge's department indicating that you have a certain amount of training to meet competency levels. When folks come into the dependency court, if they're free to retain a lawyer, a private lawyer, a lawyer that they pay. However, that lawyer doesn't have that same requirement. And in fact, sometimes judges, if they see a private lawyer that they don't recognize, they will ask them what their experience level is in dependency, and they'll make sure the client understands that the lawyer that they could appoint probably has more experience and knowledge. So by and large, our lawyers are quite experienced, although we are always looking to hire and train new lawyers. Thank you.
Thank you, Adam. All right, Judge Bejarano.
Thank you and good afternoon to all. It's a pleasure to be able to participate this afternoon and to represent the San Diego Superior Court. I am one of 5 San Diego Superior Court judges that is specifically assigned to a dependency court. While previously we have had other judicial officers, such as commissioners, that would preside over dependency proceedings, at this time we only have judges presiding over the dependency cases. 3 of us are assigned to our juvenile courthouse, which is centrally located in San Diego. And we have a dependency judge also in our East County branch, which is in El Cajon. And we also have a dependency judge that is assigned to our Vista courthouse, which oversees the North County cases. And for cases that fall outside of the East County region and North County regions, all of those cases are brought to our central courthouse here, the juvenile courthouse. And together, collectively, the 5 of us preside over nearly 2,000 cases. And I just want to give a little bit of a background regarding judges. A Superior Court judge, prior to either being elected or appointed to serve as a judge, must have practiced as an attorney for at least 10 years. Then an attorney may either be elected to serve as a Superior Court judge, and they are elected by the residents of their county, or be appointed by the governor to serve as a judicial officer. Thereafter, once a person either is elected or appointed to serve as a Superior Court judge, then we all take an oath of office. And in that oath, we swear to uphold not only the laws of the United States, but also of the state. And we also swear to willfully and faithfully discharge all of our duties. I can also let everybody know that here in San Diego County, all of the judges that are assigned to a dependency courtroom have all asked to be assigned to this specific assignment, and that we are all working to the best of our abilities every single day. In addition, all of the dependency court judges undergo extensive training. That includes not only training related to the dependency laws that are applicable in each case, but also surrounding issues that arise in a dependency courtroom. Issues such as being trauma-informed, also training regarding substance abuse disorder, reproductive health, implicit bias, and ethics. And so those are, that's just some of the basics regarding Superior Court judges, and specifically the judges that are assigned to a dependency courtroom. And throughout today's town hall, you're going to hear that dependency court judges play a critical role in the lives of the children and parents that enter the dependency courtroom. They are asked to make very critical decisions from the time that a case comes into the courtroom until the time that jurisdiction is terminated. Among those decisions include whether or not a protective custody warrant should issue, also whether or not a child should remain placed with their parents or detained or removed later on in the case. Also, whether, for example, the allegations are true, the allegations regarding the abuse or neglect, whether it occurred, whether or not a child should be declared a dependent of the juvenile court, and whether, for example, a child should have visitation, not only with the parents, but with siblings and other relatives. Other decisions include whether a child should remain at their school of origin, and if a family cannot be reunified, what is the best permanent plan for that child, which may include options such as either adoption or guardianship, which were alluded to earlier by other panelists. Dependency court judges are also charged with ensuring that the basic rights of both children and parents are respected throughout the process, and that the public agencies and partners are meeting all of their legal responsibilities to the families that they serve. And so this is all just a small snapshot into the role that judges play in the dependency court system. But I look forward to answering more specific questions along with and in collaboration with the justice partners that are here tonight. Thank you.
Thank you, Judge Bejarano. All right, Stephen, tell us about Voices for Children.
Thank you, Your Honor. Very pleased to be here we keep saying afternoon, almost evening, right? This evening with everyone. I'm Stephen Moore. I'm the Chief Program Officer of Voices for Children. I believe now it's been confirmed I'm the baby of the bunch because I've only been working in this space it'll be 15 years this summer. But just so proud and pleased to be here with all of the esteemed colleagues that we are in this work together and collaborate with. So many folks that I deeply admire and respect for their hard work for the children and families that we serve. Before I jump into specifics about Voices for Children, San Diego CASA program, I guess I should probably start by giving a little bit of context and background, some history on just the overall CASA model for those who know a little bit less about CASA in general. So CASA is an acronym for Court Appointed Special Advocate. This is a nationally used model of advocacy, which was started back in 1977 by a Seattle Superior Court judge. There are nearly 1,000 programs across the U.S. That create the National CASA organization, and there are nearly 50 CASA programs across the state of California. Since 1980, Voices for Children has served children in San Diego County's foster care system who have been removed from their homes for their own safety as a result of concerns related to abuse or neglect and need the support of adults in their lives. And since 2015, Voices for Children has also operated the CASA program in Riverside County. We're the only organization approved by the court to recruit, train, support, and supervise community volunteers called Court-Appointed Special Advocates, or CASA. Judicial Council permits that each jurisdiction may have one CASA program. So in San Diego and Riverside counties, that CASA program is Voices for Children, and we are a nonprofit organization. So now, what is a CASA? CASAs are highly trained individuals from our community who dedicate time to get to know their assigned child or sibling group so that they can help ensure their child's needs are being met in the courtroom, in the classroom, and in the community. We essentially make a decision to follow a child through their time in the dependency system and help them navigate this pretty complex world that we are in. One example of courtroom advocacy might come by way of CASA's court reports. At regular court hearings held in every child's case, CASAs write court reports sharing observations, facts, and other important details with respect to the child's placement, their education, progress therein or barriers, mental and physical health, and then contact with siblings, contact with other family, or other important issues that might be going on in that child's life that even that child or other family might want brought to the court's attention. Our hope is that we can provide the court with information that will help the judges make the most informed decisions possible in the interest of that child. CASAs typically have just one case at a time, although some CASAs can support a sibling group if they are able and willing to do so. And that's always nice because CASAs are able to facilitate a lot of sibling connection and sibling outings when there might be other obstacles in the way from that being able to occur as regularly as we'd like to see, or that child would like to see. Aside from that, Voices for Children has a staff member in each of the 5 dependency courtrooms, or each of the 5 courtrooms that hear dependency matters in San Diego. 1 in El Cajon, 1 in Vista, and 3 at Meadowlark, our juvenile court. And those staff members review and assess and monitor and triage every case entering care. And we are able to make assessments and determinations based on the information that we're able to gather as to whether or not those children would benefit or could benefit from an advocate or a CASA being appointed. Some other areas within the scope of Voices for Children, annually, we want to review and monitor the cases of all of the children in care in San Diego, and we want to make sure that we can provide a CASA to any child who needs one. We want to increase public awareness about the foster care system as a whole, and we want to advocate for legal policies and practices that enhance the quality of life for children in care. And I know I'll be covering more about the role of CASA later, so I'll turn it back to you, Judge Espana.
All right. Thank you, Stephen. Thank you very much. Okay, so let's get started with the main part of our program and start first with how a dependency case comes to be. It generally starts with Child Welfare Services contacting a family. So, Alfredo, a couple of questions. Can you tell us about how CWS knows to contact a family? And what happens at that first contact with a social worker? And what happens before the family ends up coming to court? Alfredo.
Thank you, Judge Espana. Those are excellent questions. It really all starts with Child Welfare Services. It starts at our child abuse hotline. I mentioned previously we have a child abuse hotline where anybody can call and report suspected child abuse or neglect. It's a hotline that's operated 24 hours a day, 7 days a week. And once a call is received at our child abuse hotline, and I don't know, Emily, if now would be a good time to maybe put up that triangle chart so our participants can get a view of the amount of calls we get. But our child abuse hotline gets typically, fiscal year 2021 through 2022. As you can see, we received 39,000 calls of abuse or neglect, representing about 67,000 children in Child Welfare Services. In this chart that you're seeing, it kind of has a breakdown of the ethnicity of the children, and the referrals on the calls that we're getting, and it has a breakdown on the age of the children with the referrals that we get. And it also breaks down the allegation types. As you can see, the most common allegation we get in Child Welfare Services is general neglect, which comes in about 43% of the time. That's the concern that's being reported at our child abuse hotline. So once the call comes into the child abuse hotline, there's an assessment, there's a determination made by our hotline screeners of whether or not the referral meets community standards for an investigation, an in-person investigation. And if you look at that second part of the triangle, it really shows that of the calls that we get, we went out on about 20,000 reports during that year. So about half of the calls that we get to the child abuse hotline do not get assigned for an in-person investigation. It just did not meet the standards for an in-person investigation. So those weren't assigned to go out at that point. Once a call is determined to be assigned for an investigation, it gets assigned to one of the 6 regional offices that we have throughout the county of San Diego. As you know, County of San Diego is pretty large, has beaches, deserts, and mountain areas. And so depending on the zip code of the family, it gets assigned to a particular region. once it's assigned to a region, and determination is made of how quickly we need to go out there and then do the investigation, right? And so that's actually made at the hotline. So the determination response is made at the hotline. We have two determination types in Child Welfare Services. One is what we call any immediate determination. So we need to go out there immediately within 24 hours. And those are some of our higher risk type of cases. And so just to give everybody an example, that may be a child under the age of 5 with marks or bruises, or would be considered more of a high risk situation. And then we also have a 10 calendar day response time as well. And those would be for lower type of risk referrals that we get at the child abuse hotline. That might be a teenager who's having interpersonal conflict at home or something like that, something where there's not an immediate need for us to get out there. Still something we need to follow up, still something we need to make sure we, address with the family, but it may not be something that's required to go out there immediately. And so once the determination is made, it gets assigned to a social worker, an emergency response social worker, who will then start to do the investigation. The first thing that the social worker will do is contact the reporting party and try to ensure that we got the accurate, correct information on the allegations as they're stated in the referral. Once that's completed, the social worker will go talk to essentially the family. So they're going to go talk to the children. They're going to talk to the parents. They're going to talk to what we call collateral contacts. So individuals that are involved in the life of the youth. It may be relatives, it may be neighbors, teachers, counselors. So whoever's involved in the life of the youth may be contacted to be able to make an accurate assessment as to whether or not the allegations are true or not. Maybe it may mean we get medical opinions. It may mean that we're talking to doctors and so forth. And so once we're done with the interviews, the entire time while we're doing this, we're really making sure of a couple of things. One, safety, right? We're always looking for safety of youth. That is paramount. That is what we do in Child Welfare Services. But the other things that's just as important is just making sure that we're here to support the families and make sure we keep the families intact whenever possible. Because the last thing we really want to do in Child Welfare Services is to break up a family, separate the children from the home where they're being loved, right? And so we're always working on that assumption that the family is the best place for our children to be at. And so we're always looking to see what strengths do the families have. We'll ask them what's working well within their family and how can we build on those strengths to make sure we mitigate whatever the concern may be that brought us to the attention of the family. We work towards a culturally competent investigation, understanding the family's background, their history, taking a look to see whether or not, for example, if it's a Native American referral, make sure we contact their tribe. Want to make sure the tribe wants to be involved in the investigation. We'll go ahead and do that. Many times what we'll do too is in order to avoid a removal, we'll work out safety plans with the family. Is there something that the family can put in place that will ensure the safety of the youth while we're complete our investigation, so we don't have to do a removal? We will provide services or referrals for families. If there's a need for parenting, we'll make a connection to a parenting class. If there's a need for counseling, we'll make sure we connect the family with counseling services. There's many things that we look at while we're doing an investigation. We'll look at, whatever the safety or risk concern would be in the family. We look at history, right? Is this the first time we've been out with this family, or is this the 27th time we've been out to this home, right? We'll consider the age. The younger the youth, the higher risk of the situation. The older the youth, the lower risk of the situation we have. We'll look to see what protective factors the parents have, right? We'll see, does the child have access to the alleged perpetrator? Are there any other safety concerns in the home? Is there domestic violence in the home? Is there drug abuse in the home? Our social workers don't work in a vacuum. They don't make this decision by themselves. There's a whole team behind them to make this assessment to see, to ensure the safety of the youth. That includes their management, includes their supervisor, it includes county council. Our staff are constantly communicating with county council, such as Lisa Maldonado, who's on the webinar right now. And we consider the case and take a look at everything to make sure that the child is safe before. And at that point, if there's still a safety concern and it does need the protection of the court, or the child does need to come into protected custody, then we'll start the petition proceedings at that point.
Okay. All right.
Was there anything else you want me to cover, Judge España?
No, thank you. We'll continue on. So, as you said, the vast majority of child welfare services contacts don't actually turn into court cases, but for the ones that do, Judge Bejarano, can you please explain a little bit about the process when a case is brought to the court? From the first court appearance, what would people expect, and what advisals do you give to the parents?
Sure, absolutely. So the parents will be notified of the date, time, and location of that very first appearance. And as I stated, it might be here at our main courthouse, a juvenile courthouse, or it may be at one of those two branch courthouses, either in El Cajon or Vista, depending upon where the parents reside. And so one thing that I do want to note just at the outset is that we understand that not all parents may be able to be personally present for that very first hearing. So there are other options available, which may include them calling in or having the court call them. And also, since the COVID-19 pandemic, we also allow the parties to appear via MS Teams. So that's another option, which is a virtual platform like this one. And then by the time the court matter is set on calendar, again, they're going to have the date and time and location. Something that I think is important for everybody to know is that that is not going to be the only case on that date and time. So for example, there might be anywhere between 5 and 10 cases that are set for that morning in that same department. And so there is always going to be some wait time around. And you'll hear about some of what happens during that time when my partners from Dependency Legal Services and Children's Legal Services talk about their role in the system. But there will be some wait time around. Once the case is ready to be called, then the family will be called into the courtroom. And something that was touched upon earlier, and I think that's important to again state, is that juvenile dependency proceedings are confidential. So it's only the family that's going to be admitted into the courtroom, along with any support persons that they may wish to have present, so long as there is an objection by either another party with regards to having those individuals present. So generally, it's just going to be the attorneys, the court personnel, and the family in the courtroom. And that's to ensure the privacy of both the child and the parents, the entire family. Something also that should be noted for that very first appearance is that the court is given a heads up by the agency if a parent's first language is not English, and if a court interpreter is needed. Sometimes that may be missed, but we will ensure that a court interpreter is available prior to calling the case. And that's to make sure that the parents understand all of the proceedings. They're able to communicate with their attorney if they are asking for an attorney to be appointed. So that's some of the first part. Then when the parties come in, the parents will sit next to their counsel that is going to be appointed. If they're asking for an attorney to be appointed, the child will sit next to their attorney. And then when the case is called, the judicial officer that is presiding over the case will go over the allegation. So what is the allegation of abuse or neglect that's contained within the petition that has been filed? Then the court will also review what the agency is recommending. So is the agency recommending that the child remain with the parents? Is the agency recommending that a child be detained out of home? And any other recommendations that are set forth in what is referred to as a detention report that's filed in each and every case. In addition, the court has an obligation to inquire of all of the parties, so the parents, the child, and any other extended family members, whether or not there is possible Indian ancestry. So that's something else that all the parties can expect, is to be asked about potential Indian ancestry. And that's because there are specific laws that are in place to ensure that we continue to protect the cultural identity of Indian children, and also be able to connect a tribal representative. And I think we're going to go into that later on as part of this town hall. And so after that initial review of the allegations and the recommendations, then I will hear from all of the parties and make temporary orders pending the next hearing, which is generally held in 15 court days, which is referred to as a jurisdiction and disposition hearing. And it's at that second hearing where the judicial officer would be determining the truth of the allegation. That is, was there in fact abuse or neglect that took place in this case as set forth in the petition, and then make the permanent orders, which is whether or not a child should remain placed with a parent or parents, whether or not the child needs to be removed, what services should be put in place in order to help remove whatever protective issue it was that brought the family before the court. So those are just some of the very basics of the initial hearing. And I think others might have some more details.
Thank you, Judge Bejarano. Adam, what is the role of parents' attorney?
Thanks, Judge. Our mission, while it can be complicated to execute, is pretty simple to state, and that is the goal of our advocacy is almost always to have a child return to the care and custody of our clients, their parents. That's our focus. The bottom line is that our advocacy goals are as stated by our clients, and that's almost always what they want. Almost every parent that comes into court, the one and only thing they want are their kids back home as soon as possible. And that's what we help them with. So what does that look like? Judge Bejarano talked a little bit about the initial hearing. And that's usually when we meet our clients. If they have received adequate notice, their children have very recently been removed within the last couple days, and they come to court. And as you can imagine, it's an incredibly stressful time for the parents, for the kids. The entire family is in crisis. And so we do our best to explain the court process, what's lying ahead of them, and importantly, try to build some rapport and let them know that we'll be their ally and advocate throughout the proceedings. Incredibly important legal issues are dealt with right up front, immediately, which is unique for many legal proceedings, but we get right into some serious issues right away. One of the things we always try to do is have the children, if possible, returned right away to the parents. That's something that can happen at the initial hearing, and it sometimes does. If we can come up with, if everybody, if all the justice partners can come up with something to put safeguards in place pending further court proceedings to keep the children at home. Now, sometimes some of our justice partners aren't in agreement with that, but we try to get the court to do that anyway. And sometimes we're successful. If we're not successful in that regard, right off the bat, we try to make sure children go to family immediately. So we put information in front of the court as to who family is. Hopefully the social workers have some of that information in front of the court as well. And we try to get those children placed with family immediately. We deal with parentage issues. Who are the legal parents? Who are the parties that should be involved? We deal with making sure that the family gets visitation so that they can see each other. And if And if unfortunately the siblings aren't placed together, that they get to see each other. So all this goes on at the initial hearing and right after we met our clients. The one good thing about the pandemic, I think, is that at least how it's affected practice is we get information for clients a little ahead of time, so we can call ahead of time. We can call the night before, the day before, maybe even a couple nights before, depending on when we get the paperwork. And so we can try to set some of these things up ahead of time. And that's been good, because in the old days, we would just get to court and there would be a petition and everything would happen very, very quickly. It happens quickly enough as it is. But these issues don't really end at the initial hearing, particularly in the first 16 to 90 days. There's just a ton of advocacy that goes on around the issues of essentially why are we here and what are we going to do about it, which I think is how to best summarize what jurisdiction and disposition is and what they mean. Sometimes during that phase, we are hiring expert witnesses, pediatricians, orthopedists, psychologists, etc. But these proceedings, as you know, can go on for years. So there's always advocacy surrounding trying to get the children home, either prior to jurisdiction or disposition, or after the court's taken jurisdiction, created a case plan for the family, and we are then down the road trying to get the court to see that the family has fixed those issues and that the family can be reunited.
All right. Thank you, Adam. Thank you. Carolyn, your role as the child's attorney.
Hunter, much like what Parents Council is doing at that initial phase, we are also trying to build rapport. The difference being that depending on the age of our client, that takes a different skill set sometimes. Our lawyers try to meet with the clients as soon as possible and get to know them as individuals, seek their input on the information about what's not only alleged in the petition, but what are the strengths of the family, and put in place any safeguards, as Adam discussed, of how can we leave the child with the parents safely. We counsel them on the court process, who the players are in the courtroom, who the judge is, what the judge's role is, who's making what decisions in the case, and hopefully explain through those next step type of conversations, take away some of the anxiety of what's going on in the unknown. As Adam touched upon, the parents are usually upset about what's going on, and the children may not fully understand what's going on. So this is a time in the case where there's a lot of counseling and advising going on by the lawyers. If removal from the parent becomes to be one of the issues, we then seek information from the youth about who else in their life might be a temporary place for them to live where they would feel safe and comfortable and provide normalcy, so that they're not also having the trauma of leaving the parents' home and going possibly to a stranger's home or a strange school. This is touching upon that. This is the time in the case where we're vehemently arguing for them to stay at their school where they've been attending. Those are their friendships. Those are the teachers they know, the important relationships they have, coaches, etc. So all of those supports and normalcy to the degree that we can maintain it in light of whatever the issue that's bringing the family to the court is our focus at this early stage of the case. We also are looking at the case to say, would this child benefit from the services of a CASA? Are they going to need a therapist? And, working through some of that planning, what should occur over the next 15 days before that next court hearing. We're really focused on those rights and services at the early phase of the case, and just building that relationship in a developmentally appropriate language and interviewing skills are what our attorneys are highly trained at that phase of the case.
All right. Thank you, Carolyn. Lisa, who can lawfully attend juvenile dependency hearings?
Thank you, Your Honor. So in terms of who can attend the hearings, the parent, as Adam and Carolyn have touched on, the parents and the children can attend, relatives can attend. Other interested parties, and I think Judge Bejarano touched on this, such as support people, can be allowed to attend subject to a confidentiality advisement, which is given by the court. So really, the parties have the right to be there, the tribes have a right to be there, and then the court also, I think, strives to include relatives and supports subject to all of the appropriate confidentiality advisals. And also, there are, a fair number of cases that come to the court, the initial posture in the phase of family maintenance, meaning that the children are never returned. Rather, the agency is just seeking court supervision to maintain the children safely in their family home. So it's in those particular cases, the children could come with their parents. They may indeed still be placed in their parental home, and those family maintenance cases are one of the interventions we use to strive to maintain that stability and safety in those proceedings. So it's really important for all of the parties to attend, and also to include relatives. I think Adam touched on this as well, that if children, we don't have the ability to maintain them safely with their parents, then the first line of defense, I think, for all of the court partners is to say, are there relatives that we can look to provide some safety for children while we work towards our goal of returning them home?
Right. Thank you, Lisa. All right, in a dependency case, everyone has the same goals: safety of the child and preservation of the family, if possible. And that does involve a lot of weighing of input and information. So Alfredo and Lisa, maybe start with you first, Alfredo. What is the role of CWS once a case has begun? And then Lisa, who does county council represent? So Alfredo?
Thank you, Judge Espana. Really, in many ways, once the case begins, that's where the real work for our social workers start. At that point, our goal for the social workers is to, if the child is placed out of the home, is to try to get that child placed back in their home safely, right? And so what does that mean? That means having conversations, ongoing conversations with the parents, making sure that we're addressing whatever the issue was that brought the family before the court, right? If it's a substance abuse issue, making sure that we're providing services and referrals for substance abuse treatment. If it was their mental health issues, making sure we're providing, supportive mental health services, emotional services for the family. So whatever the issue may have been, that really is where it starts with the social worker, making sure that we're having ongoing conversations with the parents. If the family is referred to services, checking in with the service providers. How are the family doing? Are they engaging? Are they learning? Are they getting something out of the services? Checking in with the parents. Do they like the treatment? Is it working well with them? What do they like about it? What don't they like about it? How do they feel they're doing? How do they feel? Are there changes being made? Making sure we try to get their voice. But it also checking in with the youth in question. How's the youth, right? So the child is placed out at home. And I think I'll just go ahead and answer one of the Q&A questions. Is I think it was, do we place children with relatives? And absolutely, that is the very first thing we try to do if a child does come into protective custody, is try to make sure we place a child with a relative that the family has designated for us to play with. And there's a process for the approval, but we can get through that pretty quickly and get a child placed in a relative home fairly quickly. And so we'll check in with the child's relative. If it's an auntie or an uncle or grandparents, we'll ask them how the youth is doing. We want to make sure we're meeting their needs as well, because it's absolutely traumatizing for the youth when the youth is removed from a home, right? And so there's services that they may need. And so we want to make sure we're addressing those services as well. In particular, if they were a victim of some type of abuse, right? Whether it be physical abuse, maybe there's medical attention that's needed. If it was sexual abuse, maybe there's some sexual abuse treatment that's going to be needed for the youth. So making sure we're addressing those needs for the youth. Many times our courts will make recommendations, and so we want to make sure that we're following all court orders as far as some of the other recommendations pertaining to the family. If a child is not placed with relatives, if the child is placed in a foster home, continue looking for relatives, continue trying to approve relatives for placement. Again, with the understanding that relative placement is the best option for our youth. Making sure that we're following up with any medical, dental services for the youth. if the child is school age, right? Are there any IEP issues that need to be addressed? One of the things that we strive to do in Child Welfare Services is called school of origin, right? And so we want to make sure we're trying to keep our youth in their school of origin. It's already traumatizing to be removed from a home, but at the very least that we can do is try to make sure we keep them in with familiar, with their familiar friends in their neighborhood, and making sure they attend to the same school. Has this affected their schooling, their education? So we're making sure we're addressing any of those needs during that process.
All right, Lisa. Who does County Council represent?
So County Council represents the agency as a whole. As I alluded to in my introduction, we represent Child Welfare Services well before the case comes into court. So we're working with them on the investigation before there's ever a court case. We're exploring with them what the options are for the family in terms of whether or not this family's needs can be met via voluntary services or some other avenue. So that constant consultation is happening before the case ever gets to juvenile court. And then if it does end up getting to juvenile court, then we will represent the agency as a whole throughout those juvenile dependency proceedings. And that's not a particular social worker, that's the entire agency. So we frequently meet with various social workers who work in different roles over at the agency to collectively figure out what the agency's recommendations might be. That includes supervisors and managers. And once we get to a point of an agency position, then we are appearing in court and advocating that position. And what's a little bit unique to the way our office is run is that our attorneys, we have 2 attorneys per courtroom. And so they will rotate days sharing that entire courtroom's caseload with one another and work together as a 2-person team to represent the agency's interests on all of the cases assigned to that particular juvenile dependency courtroom.
All right, thank you, Lisa. Carolyn, was there anything more you wanted to add? One of the questions was, what's the role of the guardian ad litem?
Sure, Your Honor. I'll just add on a comment too that we actually carry our caseloads a little bit differently. Our youth are assigned to one lawyer primarily, but the law firm as a whole represents them. So they do meet our investigators often to go out to the homes and check on them at the placements wherever they are. Part of that is because of our duties as a guardian ad litem. So we have an amazing investigative team that supports our lawyers that are in the courtrooms. Because in the state of California, the legislature has decided that we're not only supposed to hold the legal duties and the ethical duties as a traditional lawyer, which would be meeting and consulting with our client and arguing zealously in the courtroom for what the client wants. But we also wear this dual role hat of a guardian ad litem, which is supposed to be telling the court on each of the cases what we've learned with our firsthand knowledge of investigating the case independently and making recommendations to the court concerning the best interests of the child. And the reason we have that dual role is because, again, a lot of our clients are very young. So representing a toddler who's not expressing to us what they think would be the trajectory of the case or the legal strategy in their case to get home to their parent, we're doing so on their behalf as the guardian ad litem due to their limited capacity due to age. So that's sort of our dual role that we have as children's attorneys. And there was a question in the chat that I thought I would address at this point is how many, these expansive caseloads of child welfare as well as our lawyers. We are funded through the state of California does provide funding for lawyers to be assigned for both children and parents. And the funding is set so that we are having a lawyer for 140 clients for each lawyer. I'm happy to report that San Diego, both Adam's organization and ours, staff that much more liberally. Our attorneys do not have 140 cases or clients each. We are well below that standard that the state pays us for. Due to the fact that we're nonprofit, we fundraise to keep our caseloads low so that we can give individual youth the attention and time and advocacy that they deserve. So hopefully that sufficiently answered that question.
Yes.
Thank you.
Thank you, Carolyn. Adam, why do spouses or partners each need their own attorney in a dependency action? And if they're on the same side, sometimes the question is, why do they need separate lawyers?
Right, and that's a good question. Parents always get different lawyers, and sometimes, we're talking about 3, 4, or even 5 lawyers on a case because we could have a family with different stepfathers, and so they do that. We do that because some of the things we've been talking about, these cases go on for quite some time. New information's developed, people change their minds about priorities, et cetera. And so people need to have their own lawyers so that they can allow for things like that to happen. Even if you have a mother and a father who come into court who are absolutely aligned and have the exact same goals, that's great, and there's absolutely nothing wrong with that, and that's how we would advocate for those parents. But what has happened, what I've seen happen, is that 6 months down the line, perhaps one parent has a different idea of how they'd like to see things go, or perhaps new information emerges that changes how one parent feels about what they, sometimes about the other parent, but sometimes about just advocacy goals and case goals. So that's why if we had one attorney, then that attorney would have to be relieved and 2 new attorneys would have to be appointed down the line. So it makes more sense to just start everyone out with their own attorney, makes it cleaner, ethically and practically.
Right. Thank you, Adam. All right. Assuming that it's decided a child needs to be removed from their home, Judge Bejarano, can you share some possible reasons for that removal? And what goes into the decision about where a child might go?
Sure, absolutely. So if we go back to this slide that was put up earlier, we don't need to put it back up, but in that slide, it showed that over 40% of the cases that are filed, the petition is filed in court, is a result of general neglect. And so that's when there is a concern that a child has either suffered or is at substantial risk of suffering serious physical harm or illness as a result of a parent's conduct. And for an example, that can be as a result of a substance abuse. And so one example of when removal might happen is in the case of a newborn child, when that child at birth tests positive for a controlled substance. And the information before the court is that both parents are continuing to use controlled substances and or there is no evidence of sobriety. So in that situation, generally that newborn child will be removed from the home because until the parents are able to refrain from using controlled substances, while caring for the child, that child is at substantial risk of harm. And so if removal is necessary in that case or any other case, the court is first going to look at, can this child be placed with a relative or what is referred to as a non-related extended family member? That is somebody that is described under the law as having an existing relationship with a relative of the child. And so the reason for that is because, we've heard everybody talk about the trauma that the children experience if they have to be removed. What the studies show is that when a child is placed with a relative or non-related extended family member, that minimizes the trauma to the children. And also, it's generally more likely that will be a stable placement if we're able to place with a relative or a non-related extended family member.
All right. Thank you, Judge Bejarano. We received this question through our online survey, and maybe this is a good one for you to answer. Are grandparents able to request visitation when a child's under dependency proceedings, and who would that request be filed with?
Just to clarify, it's asked to the parents. Are the parents able?
Are grandparents able to request visitation when a child is under dependency proceedings, and who would that request be filed with?
Yes, absolutely. Grandparents are able to request visitation. That request can be made directly to the assigned social worker. Also, if those grandparents are present at a court hearing, generally the social worker is there in person. But if not, they can also make the request to the child's attorney. They can let them know that they are seeking to visit with the child. They can also let county council know that they would like visitation, or they can also simply ask to be heard there in open court and let the judicial officer know that they are the grandparents of the child and that they are asking for visitation. When that happens in my courtroom, I would generally turn to county council and ask that the social worker look into whether or not it's possible to facilitate visitation between the grandparents and the child.
All right, thank you. Maybe this question to you, Alfredo. Can a parent select or make a suggestion that a child go to a specific family member or friend as opposed to going into foster care?
Thank you for that question, Judge Espana. In short, the answer is yes. One of the things that we do in Child Welfare Services is called a CFT meeting. And that's a meeting where we want to bring everybody who's involved in the life of the child together and really have a conversation with everyone over a couple things. One, why we're there. And two, is there anything we can do to kind of mitigate some of those issues and concerns? Can families support the family? Can families support the youth? And then the other thing that we're looking for is we want to make sure we do place the youth with a relative, right? And so then we'll start having conversations about relative placement. Who's able to take the youth into their home, and have the family have a conversation about that. Because in many of our situations, we'll have multiple relatives that are stepping up, and which is great. It's amazing, right? There's nothing wrong with that, right? And so we'll have the family kind of sit together and have a conversation about, where might the child be best placed, right? And so, in short, Judge, the answer is yes. And I'd be remiss if I didn't take the opportunity right now, Judge Espana, to kind of talk about one of the current needs that we have in Child Welfare Services as we're talking about relative placement and foster homes is, in Child Welfare Services, we have a need right now for foster parents that are willing to take teens, foster parents that are willing to take African American youth, Latino youth, in some of the historically disadvantaged neighborhoods. We have a need right now for foster parents that are willing to take medically fragile children, LGBT youth. So there's always a need for that. And in particular right now, many times whenever there's a situation and an issue in the home, it doesn't affect just one child, but it'll affect some multiple children. And so there are many instances where sibling sets need to come into protective custody. And so there's always also a need for foster homes that are willing to take a larger sibling set. Because the last thing we want to do is separate siblings, right? And so we want to make sure we keep them together. And so just a call to action out there and a plug for any foster parents.
Thank you. And that's somewhat related to another question we got from a member of the public through our online survey. And I'll go ahead and ask it. Maybe you could add to your answer from the last question. But with a shortage in resource parents, low numbers of teens at Polinsky and in juvenile hall and group homes closing, where are all the kids going?
Great question. And so it kind of showed a little bit on that triangle chart that we had, but I'll just talk about this current fiscal year where things stand at right now. So on average for this fiscal year, 42% of the youth that are in out-of-home placements are placed with relatives. 8% are placed with what we call FFA homes, which are foster family agency homes, and those are privately licensed foster homes. 11% are placed in a court-specified placement. 2% are at San Pascual Academy. 4% are at a STRTP. It's a fancy name for what used to be called group homes. We call them STRTPs right now. And 2% of the youth are currently at Polinsky Children's Center.
All right, thank you. I see that we've got about 5 more minutes before we go to the questions that we've received on the Q&A. We'll probably try to do that in about 5 minutes, but let me jump to you, Lisa. Does every parent get reunification services?
The vast majority, well, the short answer is no. A little bit longer answer is the vast majority do, but there are statutory exceptions in certain cases which allow for the parent being denied or bypassed reunification services. I won't go into the list of those, but I will just give a few brief examples. There are more severe cases, such as where a parent has caused the death of another child, where there's severe physical abuse by a parent of a child under the age of 5, or cases in which the parent has previously been in with the same constellation of issues, failed to address those and failed to reunify, and then presents yet again with another child and still has not addressed any of those issues, despite the intervening time and the prior provision of reunification services. So the court can give a stricter look to those sort of cases that could be continuing to cycle through. So I think the short answer to your question, Judge, I know we're running short on time, is the vast majority of parents do receive reunification cases, but there are a certain statutory bucket of provisions which would allow for the court to deny the parent the reunification services and head right towards permanency planning for that child.
All right, thank you. Let me jump over to Stephen. Give me just a few examples of what a CASA's volunteers' involvement might look like during the reunification stage.
Sure. During the reunification stage, we are, first and foremost, we like to start CASA's focusing on just getting to know the child that they're going to be working with. What are their likes and dislikes? What makes them comfortable and feel safe? What's their favorite color? And song and music that they like. I mean, just the very simple things. And I know it sounds a little disconnected from some of the gravity of what others are talking about during these particular proceedings, but it's really difficult to advocate in the best interest of a child or for their needs when you don't know them. So that's really where we like to start CASA's focusing on, very simply. Get to know that child, get to know the people in their decision-making circle. Who are the people that are going to be going to the CFTs that Alfredo mentioned? Who's the attorney? What is some perspective from the attorney? Who's the social worker? Maybe getting some background and some historical information from the social worker that might be helpful either now or at a later date. Trying to figure out what the situation is for the parents, and are there any ways that we might be able to help facilitate visitation between siblings or between family members or extended family members? How else might we be useful? Is there someone needed to step in and hold education rights, whether that be solely by the CASA or hopefully we can get to a place that we can jointly hold with a parent or both parents during this process, so that we know the child's educational needs are also being met. CASAs are oftentimes attending parent-teacher conferences or talent shows at school or sporting events, getting their child enrolled in extracurricular activities or pro-social events in the community. Doing anything we can from that, like Carolyn mentioned earlier, from those infants all the way to 21-year-olds who are exiting care and need help and assistance and support in that transition. It could just look so different. But there is just a vast ocean of tasks and gaps that we can help fill when we're assigned to these cases.
Thank you, Stephen. One of the other questions we received from our online submission was, how do you help parents with education about their child's mental health problems? And maybe Alfredo, you want to take this one?
Yeah, so our social worker, at the very least, has monthly visits with the parents, but frequently has much more frequent visits with each parent. And so what we can do is we can refer them to counseling services, parenting classes. And I know many times in our parenting classes, a lot of the modules or trainings that are involved in parenting classes is really understanding the needs of the youth. And so we're able to provide support to the families that way as well. We also have local programs in San Diego County. It's called CSF, where we're able to provide families who have lived experience. So families who have gone through the child welfare services process and have reunified with their children. We can provide them as partners, as mentors, to kind of help the family through the whole process, the child welfare services process, but at the same time, helping them understand some of the needs that their youth may have during this process.
Thank you, Alfredo. Well, let's go to the questions in the Q&A. I hear there have been several questions submitted. And so Judge Martin, you've been reviewing them. You want to go ahead and ask the first question?
Yes. First, thank you to the attendees for being so thoughtful in the questions that have been asked. I'm hoping we can get through quite a few of them. And if not, we'll have to respond at a different time. But one of the questions that was asked was around caseload for social workers, asking about how many cases does each caseworker handle, and are there any issues around being short-staffed, and why are social workers, if they're assigned, not assigned to the case for the duration?
All right, I guess Alfredo, that goes to you.
Thank you, Judge Martin. So first I'll say we are hiring. So if anyone's interested in becoming a social worker, please go into our county website. Secondly, it kind of depends on the program as far as what the caseload looks like. So we don't have what's called, and I think that's the question, is do we have a vertical caseload? Meaning, do we have a caseload? Does the youth have the same social worker from the onset of the investigation through permanency of investigation or reunification? And the short answer is no. We have separate social workers to do separate tasks and work separate programs. So, for example, we have emergency response social workers who do the initial investigations. They're the ones that do that first knock on the family door, gather the information, gather the facts. They typically get assigned anywhere, a full case carrying social worker, once they're fully trained and up to speed, anywhere from 12 to 13 referrals a month is what they're normally carrying. An investigation will take anywhere from 30 to 45 days to complete. So that's what their caseload looks like. Someone who has in a reunification caseload or carrying a family maintenance caseload is probably carrying about 18 youth per social worker.
Thank you, Alfredo. All right, Judge Martin.
All right. There was a question that was asked about, is it true if a child that is 12 years old, if they can make a decision about whether they remain in a group home or if they're adopted? And if that is true, is that too young for a child to be making such a decision?
All right, Carolyn?
Thanks. Yes, there is some truth to that. It rephrased a little bit differently. The legislature set the age of 12 or older as where there's an exception in the law for termination of parental rights and an order of permanent plan of adoption. So if there's a 13-year-old that does not want to be adopted, they do have the right to object to that. And that would be an exception to terminating parental rights and ordering that plan of adoption. Whether I think that's too old, too young, that is our role at that point. It's a right under the law that the legislature has written, and we do explain to the youth that is their right and counsel them about the different options they have, not only of the plan of adoption, if that's where they're headed in their case, and that's one of the things that's being discussed as a possible plan for them, but also that if they would object to that and choose and prefer not to be adopted and not to have parental rights terminated at that stage of the case, what the options would be upon making that exception to that. So, we spend a lot of time talking to the youth and counseling them. If at that stage of the case, it's a very serious decision point in most cases when rights are going to be terminated with a parent that would also terminate many other rights with siblings, et cetera. So that's a huge stage of advocacy on our client with our clients to make sure they fully understand their rights and the options that they have. Very serious decisions, yes.
Thank you, Carolyn. Judge Martin.
There was a question asked about what happens if a parent does not show up for their court appearance, and this came up during the discussion about detention hearings.
All right, well, Judge Bejarano, you want to take that?
Sure, absolutely. So if a parent does not attend that initial hearing, then what I'm going to be looking at is, were the parents properly notified if their whereabouts were known? And so were they notified of the time, place, and location of the hearing? If the whereabouts of the parents are not known, then did the agency conduct a due diligence to try and locate the parents? So notice at that very initial hearing is important to confirm that it was in fact given. And if the parents were properly notified of that initial hearing, but have elected not to be present for whatever reason, then the matter will go forward.
Thank you. Judge Martin.
Okay, there were a couple of questions around Child Welfare Services investigations. One question was asked, how do you get the parents to talk to you that are accused of causing abuse to their child? That was one question. And the other one was, are the parents obligated to talk to the child welfare investigators?
Maybe we'll have the first question answered by Alfredo, and then Adam, maybe you could take the second one. Alfredo?
Thank you for that question, Judge Martin. Our social workers obviously come in with, a social worker background, degrees, and behavioral health. So they come in with a certain amount of skills, being able to interact with families, being able to have conversations. There's also an 18-week training that they go through with us in Child Welfare Services. We'll teach them engagement skills. We'll train them on solution-focused questions that really try to elicit and get information. But I think one of the most important things that we do is really try to help the family understand that we're a partner in this. We really try to help them understand that, our goal is not to remove your child. Our goal is not to keep your child out of the home. We want to work together to be able to kind of find a solution where, we can make the family whole again, or we can keep the family intact.
Thanks, Alfredo. Adam, about parents talking with social workers. What do you say?
Well, I think the question was, can you be compelled to speak with a social worker? And you do not have to speak as a parent. You do not have to speak with a social worker. You do not have to be interviewed by them if they request an interview. Does that mean you shouldn't? Not necessarily. I mean, I think it's very fact dependent. It may behoove you to speak with the social worker. It may help them close their case out quicker and be on their way. But there's certainly, I can think of many cases where I would not have my client speak to the social worker.
Thank you, Adam. Judge Martin.
There was a question also asked about, are unaccompanied and homeless minors able to be investigated and receive social worker services and support?
All right. Alfredo or Lisa? Lisa?
I think I can safely say yes. We receive those types of referrals routinely. The agency is able to investigate and assist youth. And whether or not those youth would meet criteria for a court case is a completely different matter. That would be an assessment that we would probably have a consultation with the investigating social workers out in region to know more about the circumstances, right? About, why the youth is unaccompanied or why the youth is homeless and what are the circumstances that led to that, and what support resources do we have to try to address that situation. Would be, I think, more lengthy conversations we would be having out in region before we would even be discussing any possibility for court intervention. And Alfredo, you can add or correct me if I got any of that wrong.
You got it. Thank you.
Thank you both. All right, Judge Martin.
There were a few questions around court-appointed special advocates. One question was, does every child who needs a CASA currently have a CASA, or is there a lack of qualified CASAs to serve the youth?
Right.
Yeah, thank you for that question, Judge Martin. We do have a wait list of children that are unfortunately waiting for an advocate. Every year we're tasked with bringing in 200 to 250 new court-appointed special advocates and getting them through training process. But we do we operate on referrals, so we get referrals from social workers, from minors attorneys, from family members, and from the children themselves from the court. And so we have to triage all of those referrals, and then we also do our own independent assessment and triaging of cases to determine what that wait list looks like. And we obviously have the goal of not having children wait long for the support of a court-appointed special advocate. But it does happen when we are in need of CASAs always. So since Alfredo did, I will do the same and plug speakupnow.org if you'd like to look up what are the requirements to becoming a CASA. We have a very selective screening process. Not all that apply, even close, become CASAs, but I would encourage you to definitely, if you feel compelled to do so and you feel you have the time to dedicate, look us up on speakupnow.org, attend an information session, and find out more about what the requirements are and whether or not you feel that would be something that is your calling.
All right, thank you, Stephen. So Judge Martin, we have one more minute before you take us to our closing. Is there a question that is really, we can answer quickly?
No.
Okay.
We have questions that still need to be asked. We were not able to complete them all, but I have made note of them so that way we can follow up regarding those responses. At this time, just to be respectful of everyone's time, we certainly are going to close out the town hall given the time of the hour. So having said that, I would first like to thank presiding juvenile court judge Ana España for moderating this afternoon, as well as thanking our panelists for participating. I also would like to thank the San Diego Superior Court and staff for helping us to host today's town hall. But most importantly, I would like to thank the participants and the attendees for showing an interest in learning about juvenile court. We cannot do this work well without support from our community and justice partners. There is a survey link for today's town hall. It will be available in the chat box, or also available is a link on the screen for the webinar, and also a QR code that you can scan. We are certainly seeking your feedback regarding today's town hall, and it also is an opportunity for you to submit additional questions or resubmit a question if we were not able to answer it for you today. We're asking you to mark your calendars as our second town hall in this series will occur on Thursday, September 14th from 4 p.m. to 5:30 p.m., where our expectation is to bring to you a lived experience panel who will discuss their journey through juvenile court. This lived experience panel perspective is important to inform our understanding about how we as professionals can continue to improve in our engagement with youth, families, and their communities. And finally, we cannot discuss juvenile court without discussing juvenile justice. And we do plan to bring to you a town hall series in 2024 regarding our juvenile justice court as well. Everyone, thank you so much for your time and attention, and have a good evening.
Thank you, everybody. And thank you for joining us tonight. Bye-bye.